Judgement. The applicants are Jan-Francois Engelbrecht, Dion Marius Botha, Alan David Pello and Baron Peterson, acting in their capacities as joint provisional liquidators of the Pamotsi Group of Companies. The respondents are Khulubuse Zuma, Zondwa Gaddafi Mandela, Shishile Thulani and Ngubane, Suleiman Bana, and Faisal Bana. The applicants, as provisional liquidators, apply for a declaratory order that the respondents, jointly and severally, the one to pay, the others to be absolved, be declared liable for all debts and liabilities owed by Aurora to the Pamotsi Group of Companies, as provided in Section 424 of the Companies Act 61 of 1973, read with Section 77 and Schedule 5 of the Companies Act 71 of 2008. The Pamotsi Group of Companies comprise Pamotsi Gold Orkney Pty Limited, Pamotsi Gold East Rand Pty Limited, Nigel Gold Mining Pty Limited, the Grootvlei Proprietary Mines Limited, Consolidated Modderfontein Mines 1979 Pty Limited, and Consolidated Modderfontein Mines Limited. All these companies are in provisional liquidation, the provisional orders having been extended over the past few years from time to time. Unsurprisingly, the applicants also seek a costs order in the event that their prayers are granted. The judgment then deals with the factual background presented in chronological order, which I will not record at this and not read at this stage. At the end of the factual summary, the judgment continues as follows. The applicable legislation. The parties are at idem that the Old Companies Act 61 of 1973 applies to the present dispute. Section 424 of this Act reads as follows. Liability of directors and others for fraudulent conduct of business. 1. When it appears, whether it be in winding up, judicial management or otherwise, that any business of the company was or is being carried on recklessly or with intent to defraud creditors of the company or creditors of any other person, or for any fraudulent purpose, the court may, on the application of the master, the liquidator, the judicial manager, any creditor or member or contributory of the company, declare that any person who was knowingly a party to the carrying on of the business in the manner aforesaid shall be personally responsible without any limitation of liability for all or any of the debts or other liabilities of the company as the court may direct. I will not read the further subparagraphs. Applying the law to the facts. The respondents were represented by two legal teams, the first respondent having instructed his own attorney and counsel. As will become apparent later, the first respondent's situation does indeed differ from that of the other respondents. In what follows, all the respondents will be referred to as the respondents unless it is necessary to identify the first respondent as such. The applicants rely upon Section 424 for the declaratory orders they seek that the respondents should be held personally liable for Aurora's debts owed to the insolvent companies. They must consequently provide proof on a balance of probabilities that all 5 respondents are individually guilty of intentional deceit or are each in his individual capacity guilty of reckless conduct of Aurora's business. Recklessness may consist of blameworthy conduct characterized by a failure to take any due care in the management of a company that results in detriment to the company and others, and exhibits a high degree of disregard for the standards observed by honest and diligent men of affairs. It may, however, also be demonstrated by a similarly uncaring and careless failure to attend to the company's business or to prevent foreseeable harm from being caused by failing to take reasonable preventative measures against such eventualities. See Cronje and O versus Stone on a 1985 3SA 597T. In seeking to establish that the respondents are guilty of fraud, the applicants rely primarily upon the content of the bid documents prepared by the respondents or on their behalf at their behest, which were presented to the applicants at the commencement of the negotiations to acquire the Pomotsi mines for Aurora. Because of the significance of these documents, the first is quoted in full. The second is couched in similar terms and will be quoted only to the extent that it differs from the earlier one. Binding offer, Pomotsi Gold Orkney Pty Limited in provisional liquidation. Aurora Empowerment Systems Pty Limited, a specialist investment vehicle established to make strategic investments in a diversity of categories in the sub-Saharan African region. The board of directors has been well constituted and balanced in that Mr. Khulubuse Zuma, chairman, Mr. Zondwa Mandela, managing director, Dato Raja Zainal Alam Shah, executive director, Malaysia, Mr. Shishilian Ngubane, executive director, Mr. Abdullah Belhoul, United Arab Emirates, UAE. Non-executive director will be appointed on the 1st of August 2009. The company is a South African-based BEE company. Aurora Empowerment Systems Pty Limited purchased 71% of being the controlling interest of Senmag Limited, a public company listed on the Johannesburg Stock Exchange, JSE. This was in line with the Board of Directors' strategic acquisition program, and thus allowing for more transparency as well as the highest level of corporate governance associated with a listed company. The BOD make the company a global player in the truest sense, since the Malaysian director and shareholder has been knighted by the King as Sir or Dato, as well as being a seasoned and respected banker, setting up not only Maybank, Malaysia's largest bank, but also Al Rajhi Bank, Saudi Arabia's largest Islamic bank. Aurora's acquisition of the largest sawmill in the Southern Hemisphere, Redwood Timber Merchants Limited, with its timber concessions, has propelled the company to the forefront of global timber supplies, with the core focus being the Gulf and Far Eastern market. Aurora, with its strong links to the Gulf and Far East, is positioning itself as a major player in the commodities supply market. Aurora's mission statement: to be a major contributor in the mainstream of the Southern African economy, to not only assist in the job creation initiatives, but to also preserve existing employment opportunities at grassroots as well as national level. With the current Pomotsi Gold Orkney operations being a major source of employment in the Northwest Province, it is imperative that an operator with a long-term view enters the fray in order to resuscitate the operations. Aurora also realizes that Pomotsi Gold Orkney operations is the largest employer in the area, where the official unemployment rate already exceeds 40%. Aurora is the most suitable operator in that it will recruit the most experienced management, as well as necessary technical expertise to maximize shareholder interest, which in turn will ensure long-term sustainability and stability. Aurora is of the firm belief that the key to Pomotsi Gold Orkney operations' existence in the short and medium term and survival in the longer term is a capital investment program. This to be in the form of completion of Shaft 2, the upgrade of Shaft 1 and 3 pillars, together with an increase in volumes of shafts number 4 and shaft number 7. The drop in shaft number 3 ore grade and ultimately income is as a result of the depletion of the pillars, which would make the end of the mine shaft 3 2010. Aurora will replace new blocks and satellite shaft pillars, which will result in a sharp increase in production as well as the life of the mine. The research and development team of Aurora have estimated an amount of 150 million rand would be required as short-term capital investment to ensure the sustainability and enhance long-term life of the mine expectancy. The above examples are to illustrate that the key to the life of the mine, as well as sustainable profitability, is the driving force to secure long-term employment. Structure of the offer. Aurora will not retrench any of the permanent employees of the Pomotsi Gold Orkney operation, being approximately 1,500 employees. Aurora will re-employ with new packages and under acceptable terms and conditions in line with current market remuneration packages all staff. Aurora's social and labour plan will include an aggressive share incentive scheme. This will incentivise the current as well as future employees at company level as well as group level. The share incentive scheme will ensure a sense of belonging as well as reward staff financially. Aurora believes in empowerment in the true sense of the word. Aurora Gold Orkney Community Trust will be formed with the sole purpose of uplifting the community. This will include as a matter of priority a healthcare services plan. Apart from this being provided by in-house company clinic facilities, it is imperative that hospitals and mobile clinics be accessible to the community at all times. The Trust will provide in-house funding for programs such as housing development for first-time homeowners, bursaries for dependents of staff members, subsidies on tertiary as well as secondary education for dependents of employees. Aurora is of the firm belief that the basic human right is the right to own home. This we will vigorously endeavour to make sure each employee has. Aurora understands that it will acquire the environmental rehabilitation liabilities associated with the purchase of the Pretoria Gold Orkney operations. In this regard, Aurora will implement a strict environmental protection plan. An environmental protection committee will be set up solely with the task of environmental rehabilitation, with the knowledge that we have a responsibility to preserve the status of the environment. Sufficient resources will be provided to ensure that environment risks are minimized and public welfare is protected during and long after our mining activities have stopped. Aurora will be a firm supporter of the Conservation Trust. The capital requirements for expansion, which we have envisaged at 150 million rands, will be invested in much-needed development of new blocks and upgrading of existing blocks. Aurora hereby tenders an offer of 250 million rands for the Pretoria Gold Orkney operation. This offer will be either for the assets of Pretoria Gold Orkney or in terms of Section 311 of the Insolvency Act. Aurora will engage into a management agreement with the joint liquidators of Pretoria Gold Orkney to manage PGOR from the 1st September 2009, whereby all profits, if any, will be shared on a 50-50 basis. Losses are for the sole account of Aurora. The above offer is subject to the following conditions precedent: the mining license being transferred to Aurora Empowerment Systems, PGOR on possession of a new order mining rights which will be transferred to Aurora in the event of a Section 311 compromise not being pursued. Aurora Task Team is allowed full access to all facilities and operations, while formal Department of Mineral and Energy approvals are in progress. This includes, but not limited to, shaft inspection by Aurora's designated mining and geological experts, meetings with employees and recruitment of further necessary expertise, as well as any other access to ensure the smooth transition. Aurora being able to formally commence mining operations by not later than the 1st of November 2009, this due to the fact that any further delays could cause asset quality deterioration, which in turn could result in Aurora having to incur additional and unanticipated capex costs. JSE approval of the transaction. Payment terms. Aurora will raise via a rights issuance and vendor placing in its Johannesburg Stock Exchange listed company an amount of 200 million rands. Aurora will pay in cash the amount of South African rand 15 million. We also attach a copy of the Standard Bank high-level due diligence pack in respect of Pretoria Gold Limited, which we considered carefully in preparing this offer. Attachment A. We await your positive reply. Zondwa Gaddafi Mandela, Managing Director. Thus far, the first bid document. The second bid is couched in largely identical terms as the first. It records Mr. Hali has been appointed as a non-executive director, but omits the name of Mr. Abdullah Balul as a non-executive director. It underlines that Aurora is well capitalized to fund the second offer. Sorry. In the discussion that follows, it must be borne in mind that the first respondent apparently did not participate in the preparation of the bid documents and may have been unaware during the period June 2009 to November 2009 of the serious problems that existed in Aurora's management of the mines from the outset. Where reference is made to the respondents in respect of any occurrence prior to November 2009, the first respondent is not included in that collective. There are several statements contained in the two bid documents that do not represent the true state of Aurora's affairs. Aurora had not acquired any shares in Senmag and did not control this listed company. Its directors had, without having invested a single cent in the former, concluded a contract for the acquisition of the majority shareholding that was entirely dependent on funds being provided by outside parties, either in cash or in shares in another company. The statement that this acquisition was, quote, in line with the BOD's strategic acquisition program, unquote, turning the company into a, quote, global player, unquote, is the figment of an overactive imagination. Aurora was hardly doing any business at all at this moment. The further claim that Aurora had acquired, quote, the largest sawmill in the Southern Hemisphere, unquote, is similarly devoid of factual content. Again, a contract had been entered into financial wherewithal, whatever, and its implementation was similarly dependent upon finding outside investors prepared to fund the transaction. The assertion that Aurora had been, quote, propelled into the forefront of global timber supplies, unquote, was and remained untrue. Aurora had no strong links to the Gulf states or the Far East, and had no share whatever in the global commodities supply. It had no capital at all, other than the sum of 15 million rand borrowed by the fourth and fifth respondents from members of their family and the community at about the time Aurora took over the running of the mines. Aurora was unable to invest in any venture, let alone fulfill the promises to keep the workforce of the insolvent mines in employment over the short and medium term, or maintain the mining operations of the companies that were in dire financial straits. The fact that the first respondent contributed 35 million rand at a later stage to its operation did not change that position. The statement in the second bid document that Aurora was sufficiently liquid to enter into the transaction was also false. Aurora was in fact already insolvent at that stage. It is necessary to observe in this context that not one of the respondents had any personal experience of mining activities. There is no evidence of any inspection or due diligence that was conducted by the respondents, other than to consult Standard Bank's team that assisted the applicants in introducing the mines to the market. Reliance was placed upon the opinion of Mr. Stondo, who is a mining expert, but not one of the respondents appears to have acquainted himself with the mines themselves, other than in the most cursory fashion. The respondents' approach to financing the promises that made in the bid documents demonstrates a surprising lack of acumen, insight, or care. The statement, quote, Aurora will raise via a rights issue and vendor placing in its Johannesburg Stock Exchange listed company an amount of 200 million rand, unquote, is far-fetched and factually entirely unwarranted. Aurora did not possess or control any listed company at that stage, let alone a listed entity with sufficient equity to attract 200 million rand on a rights issue. It has remained unexplained on what financial foundation the promise would be realized that the management of the mines would be conducted by Aurora on the basis that profits would be shared equally with the liquidators, while all losses would be carried by Aurora. By the same token, it is unclear how the respondents would finance the capital expenditure of at least 150 million rand in the short term. The, quote, research and development team of Aurora, unquote, has also not been identified, nor have any documents, facts, or figures been produced that would substantiate the existence and activities of such team. The document further records that large-scale and therefore very costly socio-economic projects would be undertaken, again without any indication how such funds would be generated other than by investor funds. This investor was said to be AME, allegedly a company based in Malaysia, one of whose directors was Shah, who also served on the Aurora Board of Directors. AME provided two letters referred to above confirming its intention to provide 200 million for the acquisition of the Orkney mine and 350 million for the acquisition and capitalization of the Pamotsi Gold East Rand operations. Both letters confirmed that the funds would be made available against the subscription of shares in Aurora or its JSE-listed nominee. It has never been disputed that these conditions attached to the offer made by AME. These conditions Aurora, at that stage an empty shell, was patently unable to fulfill. It is a matter for comment that not a single document evidencing any detail regarding the proposed investment, the manner and fashion of its execution, its terms and conditions, guarantees or particulars of appointments to the board or to the staff of the intended listed entity has been referred to in the entire saga of Aurora's involvement with the insolvent companies. Apart from Shah having allegedly inspected the mines, AME does not appear to have conducted any investigation into the mines or Aurora's capacity to administer them, prior to the letters having been drafted in September and October 2009. As was stated above, no funds were forthcoming from AME at all. By the time the liquidator's attorneys sent a letter of demand to AME, serious problems had developed on the mines. There had been 2 fatalities caused by underground accidents, threatened closure of the mine's entire operation, and labour unrest because of shortfalls in the remuneration of the workforce. After having received the attorney's letter demanding compliance with their undertaking, AME through Shah met with the liquidators and thereafter formally communicated its withdrawal from the project because of Aurora's failure to comply with the conditions to facilitate a rights issue or transfer its shares to the investor. To these breaches were added, quote, the poor state of the mine's asset, woeful corporate governance, lack of transparency of financial affairs and integrity of management staff, unquote, and lack of essential financial information and detailed accounting reports as reasons for AME's refusal to fund the transactions. In the light of the above facts, there can be little doubt that AME was fully justified in refusing to commit millions to a project that never progressed from grand dreams to hard fact. The assertions made in the bid documents lacked any foundation in reality. The respondents committed Aurora to expenditure totaling 550 million rand for the acquisition of assets that were at that stage already in serious, prolonged financial distress, without the company having a single cent to its name. Aurora was insolvent from the moment the offer for the Pomotsi mines was accepted and never emerged from that condition. The respondents either did not appreciate the very grave implications of the offers that the directors made, or did not care about the consequences that a fanciful and ill-founded approach to the transaction must have. The lives of thousands of miners and their dependents would and must be directly affected by any agreement entered into concerning the insolvent mines. Other than money lent from the community and funds to the tune of 35 million rand contributed after the offer by the first respondent, the respondents in Aurora had nothing to offer the provisional liquidators that could have contributed to the rescue of their insolvent charges. What gold was mined was certainly not enough to fund the operations of the mines, and according to the applicants, millions earned by the short-lived production under Aurora's management have been left unaccounted for, although this claim is in dispute. The respondents must have appreciated at all times that they would be unable to meet the conditions AME had set before any funding would be forthcoming. Aurora could never offer any equity in its shares and never controlled a listed entity with sufficient financial muscle to meet the obligations they undertook before the AM deal collapsed. The entire project was and remained a pipe dream, with disastrous consequences for many individuals who depended upon the fulfillment of the promises the respondents made without any prospect of being able to keep them. The respondents must have known from the first moment that they would wreak havoc in the miners' lives through their actions, yet they pressed ahead. In doing so, they were neither honest in respect of the undertakings made in the bid documents, nor did they act at any stage as prudent and reliable businessmen. Their disregard for the consequences of their actions, both in respect of the insolvent companies and in respect of the mine's workforce, was indisputably reckless. This disregard for the consequences of their actions was demonstrated further when the AME transaction fell through. The third respondent's assertion that none of the respondents ever visited the mines again after March 2010 has never been disputed. Apart from one or two payments made out of first respondents' own resources at the insistence of Solidarity, the workforce was abandoned and left destitute. After the AME transaction fell through, the mines went into an accelerated decline. They were put into care and maintenance at the end of March 2010. Assets were lost, either by theft, as the respondents would have it, or by unlawful actions on their part, as the applicants allege. The respondent did next to nothing to alleviate the plight of the miners or the continued decay of the mines, other than to attempt to find new funders without success. The respondents repeatedly state in their answering affidavits, and did also during argument, that they reasonably expected their efforts to secure funding to come to fruition, and that their actions are justified by this reasonable expectation. This argument is fallacious. As has been demonstrated above, the respondents could never have been under the impression that they'd met the conditions AME had imposed for the funding to be advanced. After the end of March 2010, the steadily worsening condition of the mines nullified any realistic prospect of finding a financial fairy godmother to supply the funds Aurora had committed itself to invest. The respondents argued that the Shandong Gold transaction was on the verge of being consummated when the applicants cancelled the Aurora contract, and that the latter are therefore solely to blame for the failure of the project. Apart from the respondents' say-so, there is nothing to support this assertion on the papers. As is the case with all the other transactions that failed, the respondents have presented no supporting affidavit, no documents, no letters, no memoranda of understanding or draft agreements to bolster their stance. Transactions that are entered across borders for millions of rand are not concluded orally. If Shandong Gold had been seriously interested in Aurora's proposition, there would be a paper trail. Absent the same, the mere allegation of imminent success cannot be accepted. Had the respondents' approach to concluding the original transaction been reckless, if not fraudulent, their management of the mines and their inaction after March 2010 to attend to the ever-worsening situation of the mines was no better. Their complete disregard for the consequences of their failure to implement the original transaction is inexplicable, other than they could not care at all about the damage they had caused. They should have, as should the liquidators, acted to limit further losses at the latest by terminating the agreements for the acquisition of the mines no later than March 2010 at the very outside, and placing the mines on auction if no other purchasers could be found. To the above failures must be added the fact that the respondents did not honor the ITCMA agreements at all. They failed to manage the mines properly, they failed to account to the liquidators, they failed to maintain the workforce, they failed to ensure the mine's safety. In short, they are guilty of numerous breaches of these agreements. To sum up, the second to fifth respondents are guilty of willful deception by presenting the bid documents containing numerous false assertions to the liquidators. They are further guilty of reckless management of Aurora's affairs from the inception of the ITCMA agreements to the date of cancellation thereof. The applicants are therefore entitled to the order they seek against them, both on the basis of fraudulent misrepresentations in the bid documents and on the grounds of the reckless conduct of the insolvent company's business. C. Fourie versus First Rand Bank Limited and another NO 2013-1 SA 204 SCA. It should be added that the fourth and fifth respondent made common cause with the second and third respondents in their opposition to the application, and never denied that they'd been deeply involved in Aurora's management even after the purported cancellation of their contract with the insolvent company. Other than the first respondent, they never claimed to be entitled to separate or special consideration on the grounds of having had a lesser degree of involvement with the guiding of the company's affairs than the other directors or managers. The fourth to fifth and fifth respondents must therefore be held liable in equal measure as the second and third respondents. The first respondent is in a slightly different position from the other respondents. It is common cause that he was not involved in the day-to-day management of Aurora's business. He was not directly involved in the negotiation with the liquidators and was informed from time to time by the other respondents, or Hali, about the state of affairs. His position must therefore be judged in the light of his personal circumstances and knowledge of the Aurora affairs. Fisheries Development Corporation of South Africa Limited, 1984 SA 156W at 165F to 166F. It is not suggested, however, that he was not fully informed of the serious problems that developed almost from the outset in Aurora's management of the mines. He must have known of the difficulties that arose toward the end of 2009 and cannot have been unaware of the Department of Minerals and Energy's notice to close down the Grootvlei mining operations in November of that year. It is not disputed that political clout was exercised to have this order ameliorated. The first respondent was clearly one of the two directors who could bring political connectivity to the table, and must therefore have known of the crisis that confronted the proposed transaction. In addition, he was prevailed upon to make 35 million rand of his own funds available to tide the ailing business over. At least some of these funds were diverted to the payment of security services. He did know, therefore, that the mine assets were at risk. It was therefore at the very latest during November of 2009 that he was aware of serious trouble in Aurora's affairs. He participated in the efforts to find new funders once the AME transaction fell through. He has not denied being aware of the increasing volume of negative reports appearing in the media about Aurora's involvement with the insolvent mines. He met with Solidarity's representatives, who informed them of the miners' plight, persuading him to make a contribution to their salaries. He was put upon inquiry at the latest at the end of 2009 and cannot be heard to protest his ignorance of the true situation after that date. His failure to act once he knew of the dire state of affairs is clearly a reckless disregard of his duties as a director. If he really did not know, it is because he deliberately chose not to be informed. Such an approach constitutes recklessness. See Stone versus Cronia Supra. And the first respondent should therefore be held liable for all losses that were incurred on or after the 1st of December 2009. Thus far, the judgment, the balance of the judgment deals with the various points raised by the respondents in opposition to the applicant's claims. They are dealt with individually, and the conclusion is that none of them stand in the way of acknowledging and granting the applicant's claims. And the following orders are therefore made. 1. The second, third, fourth, and fifth respondents are declared to be liable in terms of Section 424 of Act 61 of 1973, jointly and severally in their personal and private capacities, the one to pay, the others to be absolved, for all liabilities which the applicants may be able to establish incurred by Aurora Empowerment Systems Pty Limited, to Pemotsi Gold Orkney Pty Limited, Pemotsi Gold East Rand Pty Limited, Nigel Gold Mining Limited, the Grootvlei Proprietary Mines Limited, Consolidated Modderfontein Mines Limited, and Consolidated Modderfontein Mines 1979 Pty Limited, all of which are in provisional liquidation. 2. It is further declared that the first respondent is liable in his personal and private capacity to the applicants for all of Aurora Empowerment Systems liabilities to all of the companies in provisional liquidation listed in Order 1 above, of which the applicants are the provisional liquidators, which liabilities arose on or after the 1st of December 2009, jointly and severally with the second, third, fourth, and fifth respondent, the one to pay, the others to be absolved. The respondents are ordered to pay the applicant's costs jointly and severally, the one to pay, the others to be absolved. Such costs are to include the costs of two counsel. I hand down the judgment. Court will adjourn until 10 o'clock.